Hi, this is Sidney Armani with the Crowdfunding here with the Steve Cinelli and our special guest Brian Korn. Welcome to our program. We're going to be talking about Reg A Plus. The new law has been passed by the SEC. Steve, welcome to the program. It's yours, so take it over.
Thanks, Sydney. I'd like to welcome Brian Korn, who's a eminent attorney now with the firm of Manat. Hi, Brian. How are you?
I'm good, Steve. How are you?
Good, good. As Sydney opened up, this was sort of, or last week was sort of an interesting week in the terms of the Jobs Act and specifically, I believe, Title IV in terms of the promulgation of Reg A Plus. Brian, maybe you can give us a little overview on what Reg A Plus is in the context of Reg A as well as larger public offerings.
Yeah, absolutely. So Regulation A is currently on the books. It's an exemption from filing a registration statement with the SEC for offerings of up to $5 million. The offerings are not offerings of restricted securities. You can offer to accredited and non-accredited investors alike. The reason that no one has really used Reg A up till now is that you have to go state by state and ask for permission to make an offering in that state, and for the limited amount of money that you can raise, it hasn't been economically cost effective to do that. In the Jobs Act under Title IV, Congress has allowed the SEC to raise the cap on Reg A offerings to $50 million. And so last week what we had was the final vote to implement the rules that will usher in this new Reg A Plus, as it's called, transaction. There are two tiers under Reg A Plus. Tier 1, which allows you to go up to $20 million. You still have to go state by state under the Tier 1 program. Tier 2, which allows you to go up to $50 million. You have full state preemption, so you don't have to go state by state, and you're able to make offerings to accredited, non-accredited investors alike. The shares that you issue will be exempt from resale restrictions, and so the SEC has effectively created almost a half step to a full IPO.
So are companies that do file under Reg A Plus, are they subject to the 34 Act? That is the reporting requirements as other companies who file S1s and are subject to filings of Qs and Ks.
Yeah, it's actually a trick question. The answer is yes, they are subject to the 34 Act, but they're subject to different provisions within the 34 Act. The SEC has effectively created a whole new filing and reporting structure just for Reg A transactions, Reg A Plus transactions, and effectively there's new forms that that an issuer will have to fill out. The initial registration form to do an offering is called Form 1-A, and then there'll be an annual report on 1-K, a semi-annual report on 1-SA, and a current report, which is the equivalent of an 8K on 1-C. So similar to the 34 Act fully reporting company that files 10Ks, 10Qs, and 8Ks, you will have to make ongoing reports if you do a Tier 2 transaction, but that is part of the cost of opting for Tier 2. You can still opt for Tier 1, which is the old Reg A. That goes up to $20 million, and that's state by state. Those companies that do a Tier 1 transaction do not have to do the ongoing public reports.
So would these and this new portfolio of reports for the Reg A Plus, are they subject to Sarbanes-Oxley and some of the other requirements?
Yeah, so interestingly, the companies are not fully reporting public companies, so they're not subject to Sarbanes-Oxley. They are not subject to some of the other more costly areas of public company compliance, such as Section 16 short swing profit compliance, Regulation FD, the SEC and Stock Exchange board independence and board committee rules. You also will not have compliance issues with respect to compensation and disclosure and analysis reporting. So a lot of the reporting and compliance issues with respect to Sarbanes and some of the other public company compliance procedures do not apply to companies that are within the Regulation A+ reporting rule. The other interesting thing is that if you are issuing shares in a Reg A+ Tier 2 transaction, the company's shares that are issued in that transaction do not count against the 2,000 shareholder maximum cap that forces you to go public. So as you may know, there's a rule if you have $10 billion in assets, 2,000 shareholders or more, or 500 maximum non-accredited holders, you have to file for an offering or file to be a public company. Those shares are disregarded for counting purposes if they're issued in a Tier 2 transaction. However, in a Tier 1 transaction, they are counted towards the cap.
The 2,000 shareholder count, I believe that's Title V of the Jobs Act, and you mentioned Reg FD. Is there any carve-out or difference with financial institutions under Title VI, which is a lower limit of shareholder count, but how does Reg A+ play into the financial institutions space?
Oh, it's interesting. So the financial institution space isn't really addressed by the Reg A+ disregard, so presumably the Tier 1 shares will count towards the cap for financial institution, what we call the community bank public reporting rule. They will not count in a Tier 2 transaction.
Okay. Compare, which I'd love some clarity, is there's obviously the over-the-counter market. You've got these small cap companies, that trade on the pink sheets. If they fall off there, they move to the gray sheets. Compare and contrast these small issues with the OTC market.
Well, it's interesting. So the OTC market's actually very fragmented. There's, the main stock exchanges, so the New York Stock Exchange and the NASDAQ. There is an exchange called the OTC Bulletin Board, which is owned by FINRA, which are reporting companies. And then there are 3 exchanges that are run by a different firm, the OTC QX, the OTC Pink, and then a third market. 2 of those markets, with the exception of the OTC Pink, are for companies that are fully reporting public companies. And so the only break you will have on the current liquidity spectrum is that you'd be able to sell your shares through the OTC Pink market. I expect that second market and many of the other alternative trading systems, or ATSs as we call them, will be made available for Reg A transactions, because otherwise there would simply be no liquidity for these investors. And but as it stands now, in order to be listed on the pink sheets or the OTC QX, you do need to have a Section 12 filing, and that means that you're a publicly registered company filing full public reports, not Reg A+ reports.
Sure. We both know David Wield, who was vice chair of NASDAQ, and he's been a big critic of smaller offerings, said that the IPO business has changed dramatically over the course of a number of years. The size of IPOs is much, much greater than it used to be. One of the reasons, seemingly, is small issues don't provide, and maybe this is with decimalization, new issues don't supply sufficient economic incentives for underwriters to take companies out, and then separately to support the research in the aftermarket. Could you comment on that? You had brought up the subject of liquidity. Are we going to find ourselves in a sort of a non-incentivized way within the securities market with these small issues, and then separately the support in the aftermarket?
Yeah, so it's interesting. Part of the Jobs Act included the requirements that the SEC perform a study into decimalization, and the thought was that the small tick size increments, moving from fractions to the penny increments, created a lot less liquidity for smaller cap companies because they're less likely to attract a market maker who will publish research, follow the stock, and be able to take their effective spread. The results of the study were that decimalization and fractionalization did not actively contribute to an illiquidity discount for small cap companies, so kind of the opposite of what many people contended. And so there will not be additional concrete steps by the SEC to increase decimalization or to increase tick size increments. The proposal was that if it was appropriate, the SEC would be able to increase tick sizes for IPO companies, increase tick sizes for any company that elected, depending on what the choice of the SEC was. I personally think that when you do have a lot of illiquidity that's caused by systemic issues such as tick size, that if you did have an expanded tick size, that you'd be able to attract more market makers to the space. However, I think that's a little bit of an artificial mechanic. I think that what's going to really drive additional liquidity is investor traffic and demand. Right now, the SEC claims that only 7% of the U.S. population are accredited investors. A Reg A transaction will allow the other 93% to participate and buy in on these transactions. And so you may not be able to do as large a transaction as you can in a public offering. You can do a transaction that's dispersed to more investors, and you can do it in a way where you're not beholden to the buy side like you are in an IPO, where you have to allocate the majority of your shares to institutional accounts. So I think that the shares being held in the hands of more investors will generally encourage liquidity. The lack of trading restrictions on those shares will enhance liquidity. And then the proliferation of firms like Second Market and upcoming venture exchanges are designed to create more liquidity in the smaller cap names.
One last question for me, and I know Sydney's got a question, is given the depth of capital and seeming liquidity in the secondary markets within private equity and venture capital, compare the types of companies that may tap into the Reg A plus market versus those that have seemingly been well funded in the unregistered market through, again, the private equity firms and the venture community.
Well, I think the private equity and venture route is still the path of least resistance for a lot of companies. You know, there's obviously the give up with respect to having to run the company on venture terms and, you know, have all of the protective provisions that you typically see in a venture document. But I think that the ability to raise a large pool of capital in a short period of time, the traditional private placement / venture market is still going to have Reg A beat. I do think, though, that Reg A Plus is going to take the wind out of the sails of crowdfunding quite a bit, especially the public crowdfunding markets, because you're going to have an opportunity to go up to $50 million. You have to file a disclosure document anyway with the SEC, so why not do it under Reg A versus crowdfunding Title III? These rules are going to be in effect in June, so there's going to be a significant head start over where we're going to see the Title III crowdfunding rules when they come out. And the only real cost to doing a transaction under Reg A Plus is that non-accredited investors will be capped at 10% of their income or net worth. Accredited investors will still be able to make an unlimited amount, a limited investment amount, provided you stay under the $50 million cap. And the company has to make an investment in disclosure and infrastructure and has to do so on an ongoing basis. So I think that in the order of preference for a startup, you're generally going to see venture money still be more convenient and easier to get and to comply with. But I think that you're going to see Reg A Plus emerge as kind of the minor leagues of IPOs, where companies that may not be quite ready to go public but still want to create some liquidity for their shares and still want the ability to disclose investor information, you're going to see them use this as a half step to the public offering. And if shares trade well in the Reg A Plus market, then you might see the company file for a real IPO.
Okay, well, thank you, Brian. I know that Sydney's got a question to tee up. Sydney?
Well, Brian answered all of my questions before I asked him them. It was about the whole excitement about Reg A Plus, but opening a door for the Title III, but as he mentioned. But I want to thank you and appreciate your time. I know you're going to be in Washington in our conference in National Press Club in May 7th, so I highly recommend to everybody else. Now, if anybody wants to get in touch with you, Brian, about all these things, what is your new law firm and others?
Oh, so I am now a partner in the capital markets group at Manat, Phelps, and Phillips. I can be reached by email most conveniently at bkorn@manat, which is spelled MANATT.com.
All right. Well, thank you very much, gentlemen. Have a wonderful day and stay tuned with the crowdfunding. Thank you. Good day.
Thank you.
Thank you.